Hello dear friends, today I'm gonna do a reading task for legal English class. But before that, let me introduce myself. My name is Dwita AzzahrabNP. I'm from Class B of English class and my NPM is 221096. The reading task is I'm about to read my essay for the verdict number 258, Criminal Law 2024, Garut District Court. A description about the chronology of this verdict. On May 5, 2024, at around 2 a.m., defendant Teten Ramdan and Hilman Hakim planned to kill the victim's child, Ali Komaludin, the name is Oki, at his house in Ngamplang, Garut. Carrying a machete and sickle, they turned off the electricity to the victim's house to lure the victim out. But it turned out that the real target, the victim's child, Alec called Oki, was not at home at that time. They both continued to enter the house because they heard a fart from inside, which turned out to be the victim Alec, who was still awake. As a result, they took the victim's life because they were afraid of being caught. And they still held the same grudge as against their child. They both attacked the victim in his room. Tatan slashed the victim's head and neck using a machete, while Hillman slashed the victim's stomach and thighs using a sickle, and the victim died instantly on the spot. The next morning, the victim was found dead by his wife. The perpetrators is Teten Ramdan bin the late Rohaidin, and second one is Hilman Hakim bin Akbar Tanjung. The elements of criminal procedure: 1. Identity of the accused. Defendant 1, Teten Hilman, who is 34 years old, Muslim entrepreneur, and defendant 2 is Hilman Hakim, who is 19 years old, casual laborer. The second one is facts of the indictment. Primary, Article 340 of the Criminal Code on premeditated murder together, the first charge, and second one is subsidiary, Article 338 of the Criminal Code on murder, and this charge is used if primary is not legally proven. Facts of the act. The accused together took the life of the victim Ali Komaludin using a machete and sickle as sharp weapons at the victim Alec's house. Detention process. Detained by the investigator from May 9, 2024 to May 28, 2024. Detained by the investigator from May 29, 2024 to July 7, 2024. Public prosecutor from July 8, 2024 to July 27, 2024. District Court Judge from July 23, 2024 to August 21, 2024. District Court Judge extended by the Chief Justice of the District Court from August 22, 2024 to October 20, 2024. And then the trial process: reading of the indictment and charged by Vicky Mardani as the public prosecutor, and then examination of the witnesses and evidence, and defendant's defense, and verdict reading by the judge. The next one is judge analysis. The defendant was declared not legally proven to have committed premeditated murder and did not violate Article 340 of the Criminal Code. However, the defendants were proven to have committed murder together and violated Article 338 Criminal Code. And then the evidence found by the investigators and used by the defendants. 1 is sharp weapons in the form of machetes and sickles, and second one is jackets, helmets, and motorbikes. The next one is the verdict. 1. Declaring that the two defendants were not legally and convincingly proven guilty of committing the crime of jointly committing premeditated murder as stated in the primary indictment. 2. Acquitting the defendants from the primary indictment. 3. Declaring that the defendants were legally proven and found guilty of committing the crime of jointly committing murder as stated in the subsidiary indictment. 4. Sentencing the two defendants to 15 years in prison for that reason. 5. Determining that the defendants remain in detention. 6. Confiscating the evidence and returning the evidence that has been listed. 7. charging the defendants with court costs of 5,000 each. And the article used in this verdict is Article 338 Criminal Code of Indonesia, junto Article 55, Paragraph 1 as the Criminal Code of Indonesia. Opinions. In my opinion, in this case, the application of the law has been said to be very good, and the judge applied the principle of high justice. I followed the series of trials in this case because when this case was tried, I was doing an internship at Garut District Court, so I know the series of events that occurred in the trial. The verdict taken by the judge and handed down to the defendant is actually quite appropriate in my opinion. However, I agree more if Article 340 or the primary charge is proven, because from several series of trials and also the existing statements and chronology, it can be concluded that it was a premeditated murder, because from the series of events alone, these defendants dedicatedly exceeded the distance and time that was actually very unreasonable, if not included in a plan, which started from the fairly long distance from the exhibition to the victim's house and the need for some preparation for the weapons. Although the victim Alec was not the true target of the two defendants, the defendant's treatment of still killing Alec even though he knew that it was not his target was very cruel and inhuman. They took the life of an elder who was sitting on the mattress so brutally. In my opinion, the judge's decision to sentence him to 15 years is not enough. If I may say, a life sentence would be better, considering that the defendant Tatan was also undergoing another trial process with a different case with his twin. And if asked the decision is correct or not, in my opinion, it is correct. Only the defendant should have been sentenced a little higher, because what they did was very inhuman and cruel. However, if seen from the decision-making process by the judge, this decision is appropriate and meets the elements in the article used, namely Article 338 of the Criminal Code of Indonesia. That's all from me. See ya!